Hello, everybody, and thank you for joining us for our podcast that we're releasing today. It's focused on a recent decision of the DIFC Court, anonymized name Narciso versus Nash, that concerns the Dubai Decree that was issued in 2021, which abolished the DIFC-LCIA Arbitration Centre and made various amendments to the Dubai International Arbitration Centre, DIAC. I'm joined here today by Robert Stephen, who is the registrar of DIAC. I'll let Robert introduce himself briefly.
Hello, Mark, and thanks very much for having me. Yes, delighted to be here today and to have a conversation about this particular case and arbitration more generally. As Mark has introduced me, I'm Robert Stephen, the registrar of the Dubai International Arbitration Centre. I'm an arbitration practitioner by trade, having trained and practiced at Herbert Smith Freehills in London, Moscow, Paris, and latterly in Dubai for a little over 10 years. Leaving Herbert Smith in 2017 to join the DIFC-LCIA Arbitration Centre in Dubai as its on-the-ground registrar. I did that role for a little over 5 years and left that, went back into private practice for a bit and jumped back into institutional life as the registrar of DIAC in June of 2023.
Thank you, Robert. So, as I mentioned in the introduction, the Decree No.34 of 2021 abolished both the DIFC-LCIA and the Emirates Maritime Arbitration Centre, EMAC. And I was wondering if you could recall that period. I think you were the registrar of the DIFC-LCIA at the time, and tell us a little bit about what you thought the impact was in terms of on the arbitration scene in general in Dubai.
I think at that particular point in time, if we just take a step back and look at the environment we were in, we had 12 arbitral institutions in the United Arab Emirates. And if you'd asked anyone in the market, whether they were an arbitration lawyer, whether they were an arbitrator, whether they worked at any of the institutions, I think they would have all answered the same question, which is, do you think it's a good idea to have so many arbitral institutions in the one place? And I think they would have all answered it in the same way, which was essentially, no, it's madness, that all of these institutions are essentially doing the same thing and competing with each other. And that was just a product of these institutions being built and run and operated as part of chambers of commerce, and that's quite common in this part of the world for institutions, arbitral institutions, to be established in that way. And of course, each of the 7 emirates in the United Arab Emirates had its own arbitration centre at that point in time. And so we were in this slightly bizarre environment where we had a lot of arbitral institutions competing for the same work. And if we look at the number of arbitrations that were taking place, institutional arbitrations that were taking place at that time, it was probably around about 500, 600 cases amongst all of those institutions if you added them together. And that was something that was often lost in the international market. It was at that point in time not far off the case numbers that you were seeing at some of the leading arbitral institutions. It far exceeded the numbers of cases that we saw at the likes of the LCA, for example, and it was almost as high as the number of cases at the Singapore International Arbitration Centre at that time. And so I think we would have all said a bit of consolidation was a good idea, but how do you affect that? And so I think that the premise behind the decree is a good idea, good premise. How it was implemented and how it ultimately came into effect, it was a sovereign act. I'm not here to really comment on that. I'm not really here to apologise for that, but it's fair to say that it did lead to a significant impact for parties that had ongoing arbitrations, and for all of those involved in those cases, lawyers and arbitrators and the arbitral institutions. It had a significant impact for business on an ongoing day-to-day basis, for disputes that had arisen and were about to commence at that point in time or needed to be commenced in the 6 months that followed during the transition period. And it created a great deal of uncertainty and disappointment in the market. And from an institutional perspective, a huge amount of upheaval. So from my own perspective as the registrar of the DIFC-LCIA, yes, we tried our level best to carry on, administer the cases as best we could, and we did that really until the bitter end in February of 2023. And then a great deal of clarity was thankfully brought to bear with the agreement that was reached between the LCA and DIAC at that point in time. And I had stepped away from my role as registrar at that point in time and had no involvement with the implementation of that agreement. But I think it's fair to say that that did bring clarity, but 2021, 2022, and a good chunk of 2023 were undoubtedly challenging years for the new Dubai International Arbitration Centre. It had 6 months worth of work on its existing caseload to deal with, having largely not done very much in terms of case administration in the second half of 2021. It then had its regular caseload, as it would ordinarily have had come in 2022. In addition to that, it had the caseload that the DIFC-LCIA and EMAC, or Emirates Maritime Arbitration Centre, would have had come in the ordinary course, and 6 months of cases that had been sitting in the wings where parties were waiting for certainty. And so I think from what I've seen, at least, having gone back and looked at it, I think much of 2022 was really just catching up on work that hadn't been done, and registering a huge number of cases. And we see that from the statistics for 2022. They registered 240 cases in that year. And that was a fair increase. And I think much of that continued into the first part of 2023 when the new team came on board. We had a new arbitration court in the February of 2023, new executive director, new case counsel come in, and I joined in the June of 2023. And really the job has really been catching up since then. And I think where we are today, or where we have been really, I think, since kind of March, April of this year, is we're now at a point where we're largely caught up. There isn't legacy cases that haven't been registered, there aren't tribunals that haven't been appointed, there aren't awards that haven't gone out, should have gone out. All of that's now done. We're now in a position where if parties are filing a complete request under the rules, and the complete request is a request with all the supporting documents and pays the registration fee, that request will be dealt with and registered within 24 hours. And if parties have got emergency applications they need to make or wish to have an emergency arbitrator appointed under the rules, we're doing that within 24 hours. We're appointing tribunals pretty quickly after receipt of funds in accordance with Article 12 of the rules. Awards are going out on time, or deadlines are not being extended as a result of the administration of the case by the centre. They might be extended by agreement of the parties and the tribunal and the procedure that the parties have agreed to. But from a centre perspective, it is working much more efficiently. And that's in the context of a centre that now today has a caseload of 340 cases, arbitration cases, and 355 cases registered in 2023. And that's a significant increase over the course of the last couple of years.
And I think just two follow-up questions on that then. First, the decree made certain changes to the governance of DIAC and amended brought in a new statute for DIAC. And around about the same time, there was also a new set of DIAC rules that were brought into place. Have you found those institutional changes and changes to the rules, have they been well received? And another question, in terms of the legacy cases that you've been picking up from what were DIFC-LCIA arbitration clause containing contracts and EMAC arbitration clause containing contracts, did they make up a significant portion of the caseload in 2021, 2022? And have you seen that portion of the caseload start to narrow as time progresses and people have stopped, or hopefully stopped, putting DIFC-LCIA and EMAC clauses in their contracts?
Well, first of all, the changes introduced in terms of governance and organisation have been extremely well received, I think, outside and inside of the organisation. We now have a board of directors for the first time. The organisation before that had a board of trustees. The board of directors is chaired by His Excellency Tariq Al-Tayer, a very experienced businessman and leader, and we have board members from the United Arab Emirates, but also board members that are based outside of the United Arab Emirates. Experienced business leaders and experienced arbitration practitioners, a really healthy mix of people who give different perspectives and are really committed to the growth and the development of the centre. In addition to that, the board has formed an advisory committee, which is headed up by Anne Hoffman, and I vice chair that with her. And that advisory committee is really tasked with providing strategic guidance and advice to the board, supplementing the board and its experience with some real true arbitration practitioners from across the region and internationally. And then in addition to that, we've got the new arbitration court, as you mentioned, headed up by Michael Pryles, who is extremely experienced in that role, having been the first chair of the same position at DIAC and having headed that up for a great number of years. And he works very closely with his vice chair, Erin Miller-Rankin. And we have 13 members in that court and 11 different nationalities. And it's a very, very efficient court. It works on a daily basis on case administration. And that's a huge thing, to be able to get a decision from the court on the same day that you make a request is super helpful from an administrative perspective, but also from a party's perspective. It means, in theory, quick decision making, and that it can only be but a good thing. In addition to that, we've now got this new restructured casework team. It's unrecognisable compared to what it was before, with a clear structure with a registrar for the first time, a deputy registrar, a special counsel, 3 senior counsel, 6 counsel, and a team of paralegals and administrators sitting underneath that. And that brings with it huge breadth and scope for development in the future, and allows us to administer the cases, but also to spend some time on developing the practices and the procedures of the institution to make sure that they truly meet international best practice and standards. It also allows us to focus on other things which may be required by the institution, such as technological developments and business development and marketing. So all of that, I think, has been well received. It's working well, and we're hopeful that that's really setting a firm foundation for the institution for the future. In terms of the second part of your question and how the DIFC-LCIA caseload, what proportion of the total that currently comprises, the easiest way of saying that is that it's a reducing third. So it was a little more than a third in 21 and 22. It's about a third in 23, and if I look at the statistics from the third quarter of this year, it's a little less than a third. And I think we can envisage that DIFC-LCIA caseload will continue to drop off over time as those legacy agreements fall away through expiration or through parties agreeing to change them. And I think one of the things that we have been quite cautious about doing as an institution in the early days, at least of my tenure, is going out to the market and actively trying to persuade people to change their arbitration agreements, which, if I were in your shoes in private practice, I would of course be advising all of my clients to do that. We've been reluctant to do that because we wanted to fix the institution or the perceived criticisms that people had for the institution, and then go to the market and say, look, trust us, we've got a track record now, we've been doing this for 18 months, this is what we've done, these are the people that are administering your cases, this is what's happening on the ground, people have tried it out, it's working, now's the time to think about changing these legacy DIFC-LCIA arbitration agreements. Perhaps DIAC is a suitable choice for you to make in the circumstances. And I think we're getting to that point where over the course of the next few months we'll be going out to the market and doing a bit of that. And from what we've seen so far, given the experiences people have had over the course of the last 6 months to a year, it has been positive, and the perception of the institution has dramatically changed, and I think people are now actively putting DIAC arbitration clauses into contracts and writing out DIFC-LCIA agreements. And we're seeing that because if we have a look at our 23 statistics and our third quarter statistics for this year, the majority of the cases are coming from agreements that have been entered into in the last 5 years, with 25 to 30% of those actually arising out of contracts entered into post Decree 34. So what that tells us is that there is still a desire to use this institution and to have a DIAC arbitration agreement in a contract.
Oh, that's very interesting. So those cases that did have DIFC-LCIA clauses in them, have you seen a large number of jurisdiction challenges in those arbitrations?
Large numbers, probably over-egging it. I think if I go back to the statistics for 23, I think there were 6 jurisdictional objections raised in the total caseload in 2023. And undoubtedly, there's 2 types of jurisdictional objection, and there are 2 opportunities for the institution to consider it before it gets passed on to a tribunal. We consider our jurisdiction when we're registering a case on a prima facie basis, and we did that in 50 cases or 55 cases in 2023. That can be for all manner of reasons. It can just be a poorly drafted arbitration agreement. It could be a dispute between the parties as to what the arbitration agreement ultimately says. It could be reference to an old institution. It could be reference to an institution that doesn't exist. It could be aspects of the arbitration agreement that are questionable. So 50 or 55 of those types of assessments, and then 6 true jurisdiction objections, and the vast majority of those would have related to the question of jurisdiction that flows from the effect of Decree 34.
Interesting. And has DIAC given any guidance to those challenges, or is that something that's been left entirely in the hands of the arbitral tribunals?
It's entirely left in the hands of the tribunal, and I think that is right, and I think that is appropriate. We are a truly independent, impartial arbitral institution, and we don't want to get into the realms of providing advice to parties or to tribunals. And I think actually tribunals have been very pragmatic in the cases, and without going into any specific case details, I think it's fair to say in all of the cases they've taken a pretty pragmatic approach and have accepted jurisdiction and moved on, and I think that has largely given us some comfort that arbitrations are still proceeding and can be administered and can result in an arbitral award. At the end of the day, there hasn't been, from what I've seen at least, a huge number of tribunals that have been overly concerned about the effect of the decree.
Yeah, it's certainly been our experience, and I think as we're going to go on to discuss, there's been mixed judicial reception to the decree. So I think it's been quite positive to see that the arbitrators on the ground in the UAE have at least approached it in quite a pragmatic way to try to ensure that the arbitration agreements of the parties are preserved and they can have their disputes decided by an arbitral tribunal. Thank you very much for tuning in to our podcast episode. We had such a good in-depth discussion with Robert that we've decided to split it into 2 parts. You've just listened to part 1, and in part 2 we'll be discussing some of the cases that have taken issue with the Dubai Decree, and then we'll be moving on to the Narciso versus Nash decision.